Everybody, I appreciate you joining us tonight. My name is Jeff Oberl. I am our Training and Development Manager for Cadden Community Management. If I haven't had the chance to meet you yet, we are joined today by Javier Delgado from the CHDB law firm. And he's going to be joining us today to talk all about parking. So I'm going to turn it over to him in just a moment, but just a quick couple notes here. You'll notice that everybody does have their microphones muted for this evening, but you do have access to the chat. So please take advantage of that. If you have a question along the way, I'll be monitoring that during Javier's presentation, and we'll tackle questions as they come in or hold them to the end, kind of depending on what that question is at the time. So let me do a quick introduction for Javier. Like I said, he is with the CHDB law firm. Javier represents homeowner associations and condominium associations, businesses and nonprofit organizations throughout Arizona, New Mexico, and Utah. He has expertise in assisting boards with complex problems involving maintenance disputes, insurance claims, interpreting covenants, bylaws, and rules, reviewing contracts, gaining owner compliance, dealing with owner versus owner disputes, addressing discrimination claims, and complying with the state and federal law. And tonight, he is an expert on parking. So, without further ado, I would like to turn it over to Javier.
All right, well, thank you, and good evening, everyone. It's a crazy time to be in the HOA world. There was a AZ family story I saw on the internet today talking about how Arizona is like one of the most expensive states for assessments, because of, I think, insurance claims and how that's changing everything. So hopefully we can share some information with you all tonight so that you limit your potential liability for claims, because we want you to spend your money on fun stuff, not on those types of things. I'm just one of many over here. Actually, we just hired our 41st attorney today, so we're growing. We're excited about that. A lot of people over here ready to help you. And, what we're here to help you with and talk about with you today happens to deal with, parking, towing. How does the new law work? What about booting cars? So things like that happen. And here's what I've seen over my years of practice. The typical way that this comes across my desk is somebody picks up the phone and they say, Javier, can you help me out? I go, what's your problem? And they say, well, we've got a problem. We've got too many people, too many cars, and not enough. What is it? Not enough parking spaces, right? It's people are parking on the streets. There are, vehicles are just way bigger than they were back in the early 80s, the early 90s. People have more recreational vehicles, especially, after the pandemic. Some people got pandemic puppies. Some people got pandemic jet skis and boats. And, in condos, it's always been a bigger issue because, we're just kind of living in tighter quarters, and there's just more opportunities for friction. And then our 3-star problem, which is guest parking, and it seems to impact everywhere. So we're going to talk about all of these things, your options for regulating them, as well as your responsibilities under the law. So first thing to know is, where does that authority, that guidance for parking come from, and how it works in your particular community? It's pretty simple. It comes from your declaration or CC&Rs. If you are a gated community, you probably have a pretty good understanding as to where you can and cannot park. A lot of gated communities have signs that say, here's where the guest parking is, no street parking, or here's how street parking works. But if you have public streets, it's a little bit more intricate, a little bit more confusing, especially because of the change in the last year's legislature, House Bill 2298, which directly impacts certain communities. And if you're one of those communities, just a heads up, you're going to be a community with pre-2015 CC&Rs, public streets, and some type of authority in your CCNRs that regulates parking. So those are the communities that are going to be impacted by that new law, which we are going to talk about tonight. One of the biggest challenges, though, audience, is that you can only enforce what's written. The law doesn't make your authority any better or worse. You just have to have authority to begin with. And surprisingly, in some of these older communities, they just didn't give it much thought at all. You sometimes have here's some examples of some language that we've kind of put together. I did a quick survey of my internal audience, our attorneys over here, and I said, hey, can you send me a couple of examples of what you would think would be some typical language in CCNR? So here's the first one. This one says all vehicles of owners and their employees, guests, and invitees shall be kept in garages or residence and driveways of the owners wherever and whenever such facilities are sufficient to accommodate the number of vehicles on a lot. Now, audience, I know that you came here for answers, but I'm going to actually start posing some questions to you. It'll be the first question. What is sufficient to accommodate the number of vehicles on a lot? What do you think that means to you, if anything? Do I have any brave souls out there that have an opinion about it? If so, put it in the chat. Do we have any brave souls tonight? Everybody's going, no, I came here for answers, not questions. No. Oh, someone there? Yeah? No? Okay. Well, I'll tell you what, I don't know. It's gray. What's sufficient? Well, what you think sufficient might just, be not the same definition of sufficient in my mind. If you are someone who's looking to park as many vehicles as possible, you're going to have a view. If you're a board that's looking to restrict parking on the streets for whatever reasons, you're going to have a different view. Okay. All right. What about this? Here's another example. No automobile or other motor vehicle may be parked on any road or street in the project, except for automobiles of motor vehicles of guests of owners, which may be parked on a road or street in the project for a period of not more than 48 hours during any 7-day period. Oh, I think that's slightly better language. Where the challenge I think here is what constitutes a 7-day period. Is that like a week? Is that just 7 consecutive days? Probably it's intended to mean that. But as you can see here, words matter, because when you take people to court and you start imposing like super fines, like a lot of associations have been doing for the past couple of years, you got to be able to put your proof where your money is and show that, hey, we've got tight restrictions. So that's kind of the big thing. So there are no great answers here. It's all document specific, and we spend a lot of our time interpreting these types of, let's call them gray provisions. Well, here's a question. Can a community association tow vehicles from association-owned streets or condominium, common areas, common elements? What do you think? I'd say, yeah, absolutely, for the most part. If it's your property, or if you're at least authorized to administer or manage it, I think that's a no-brainer for the most part. Now, we could talk about what's the best way to set that up, and we could talk about what a towing company might require in terms of coverage to make that happen, and signage and so forth. But if you've got people that are parking on the green belts or the soccer fields, or they're blocking some of the common element driveways or what have you, yeah, those are instances where we can go ahead and tow. And here's just an example of some what we would hope to see in a lot of your documents. This provision says that vehicles can be towed, so that's helpful. It says that the sole cost and expense of the vehicle's owner, that's helpful. And it also says that the expense incurred is to be paid to the association. So I like that. It's a good provision. It's a solid provision, and it seems to check off all the boxes for me. Now, here's an example of a towing sign, and I get this question asked a lot. So I'm going to ask you in your minds at least, do you think that this sign is compliant with Arizona law? You can hear it from my voice, can't you? No, that is not a uh, a statutorily compliant sign. And the reason is we have a towing statute, and our towing statute has certain provisions. It says that signs have to be visible from any point in the parking area. They certainly have to be at each entrance, and they have to contain the parking restriction. What happens to the vehicle? What's the cost? Hey, if the telephone number and address to locate the vehicle. And if you don't have that, you shouldn't really be towing. We often refer to this standard colloquially, in our office as the "dude, where's my car" standard. There was this movie in the early 90s about these two probably early 20 somethings who partied too much and they could not find their car the next day. And it was because the car, I think, had been towed. I don't even remember the movie at this point. But if the two guys from "Dude, Where's My Car" don't know who to call to find their car, that's a problem. And that's going to be a legal problem for the association. Now, the good news is that if you've got an abandoned, vehicle, there is a opportunity to tow that for separate reasons. But the key there is, well, what's abandoned? I would urge a lot of you, no matter what you get out of tonight's presentation, if you're dealing with parking and towing issues, ask yourself, do we have parking and towing rules? Has anybody looked at them in the last couple of years? If not, that's the first thing. And do they address things like defining what an abandoned vehicle happens to be? It's best if your CC&Rs define that. If they don't, the next best thing would be to just adopt something in your rules. So just kind of a common sense approach there. Arizona law defines an abandoned vehicle as a vehicle that's been unattended for a period of 72 hours on public or private property. Now, here's an example of somebody who left a vehicle somewhere. It looks like maybe Eastern Europe. I'm not really up on my license plates, audience, but it's certainly been there for more than 72 hours. So that thing's been there forever. That's definitely an abandoned vehicle. It looks like it's being turned into a mini forest there. And if you do happen to have an abandoned vehicle, you can call law enforcement. You can also call a towing company. You can ask ADOT for an inspection. You can call law enforcement to come by and make a determination. So those are all helpful options. And I think it's a good thing to know, hey, what are my options? And are there any options that exist under the law? Well, what about booting? We've got an example of someone's car here who's been booted. Well, what do you think Arizona's booting statute says? There isn't one. It's a trick question. Yeah, so it's all document specific. But what we like to do is, because you're immobilizing someone's car, we like to have a policy on the booting of vehicles. So if you're going to do it, be consistent, have communication. I like to have signs about vehicles that are going to be towed. I certainly like to have signs about cars being booted as well. Is it required for booting? No. Should it be in a policy? Yeah, I like it. It's safer. And that way you show that you're treating everyone the same. So let's shift tax for a moment, shift direction, and let's talk about regulating parking on public streets. Now, I started out the presentation by talking about the fact that, one of the main drivers of neighbor versus neighbor, community versus owner conflict happens to be with regards to the classic problem of too many vehicles and not enough parking spaces. And I get asked from time to time, do you think it's a good idea to tow from public streets? As the slide would say, no, I think that's a bad idea. And the reason is that some judges would find it just flat out offensive that you would ever tow from a public street. Now, even if your documents give you that authority, you'd have to be really sure that the person's vehicle is someone who you have what we call privity, a legal relationship with the association, because they're either a owner or a resident of the association or an invitee or a guest, because we do have cases from time to time where someone throws a party a block or two away. A lot of people come. Some people park their vehicles on the public street, and the HOA does things like tow or something else, sticker them, and then they come back and they go, wait a minute, this is a public street. You don't have the right to do anything to me. And you know what? They'd be right. Why? Because it's a public street. And if they're not a member of the association, they may not be subject to any of your authority. But you know who is? Members of their association. And if you're not sure, hey, whose vehicle is this? There are ways of researching vehicles. You can send a picture of the license plate and the make and model of the vehicle, and there are third-party services that have access to the Arizona database, and it'll send out a report showing the name, the place where it's registered, and then you can at least cross-reference that with the owner list that you have. So that's one way. But definitely, if you're dealing with issues on public streets, fines and injunctive relief are the best way to go. I don't recommend towing from public streets. And speaking of public streets, to our big item of the night, that takes us to House Bill 2298. And a lot of people refer to this as the public parking bill. I think it's better to talk about it as the public roadway regulation bill. It does not apply to one-way streets, private streets, communities that are under declarant control. But no, there's no tolling for declarant properties, so it could still impact them after they leave declarant control, or CC&Rs that are recorded after December 31st, 2014. So if you've got a planned community, if there's any regulation of public roadways, and if you've got pre-2015 CC&Rs, listen up. Again, this applies to planned communities only, not condominiums. Here's an example of the exact law. And if you wanted to visualize what impact can this have in a typical community, we've got RVs here, commercial vehicles. Maybe you have speed limits. Maybe you have restrictions on oversized vehicles, storage of vehicles on the streets, porta potties, storage, other types of golf carts and RVs. But here's another thing. What about regulating bulk service trash pickup that's left on the street? What about putting trash cans out and not pulling them off the street? When you really think about this, the law's written so broadly that it establishes like this demilitarized zone where the HOA could lose all of its authority, assuming it has any at all. So how do you preserve your authority to regulate public streets? The good news, it's actually pretty simple. You have to have a vote. You have until June 30th of 2025. And the vote will be very straightforward. It'll say, there's a change in the law. The law requires us to have a vote. We're having the vote, and the vote's on whether to retain our authority to regulate public streets. Now, some communities have said it's hard to get people to participate, and you're not wrong. And so some communities have said, we're going to try to time the vote around our upcoming annual meeting. And if you'd like to do that, that's fine. You can certainly call a special meeting to, coincide the annual meeting if you think that's going to increase turnout. Quorum is actually pretty simple in most communities. For the vast majority, it's going to be the same as like to have an annual meeting. In a lot of documents, the default is typically around 10%, maybe 15, sometimes 20, usually 10% is what we see 90% of the time. I will admit I've seen some, unusual documents. Someone today in a meeting was telling me their quorum was 65%. I couldn't believe it. I didn't believe it. I looked at them and I said, wow, it is 65%. But again, 90% chance it's probably 10%. If you can get 10% of your owners to participate in the vote, you've hit quorum. And at that point, it's just majority rules. So even in a community that has, let's say, 500 lots, you only need 50 people to participate. And as long as 26 of those 50 people participate, it passes. So it's actually a pretty low threshold. We probably have done upwards of around 300 of these so far. We expect we'll probably do another, 700, maybe a couple, maybe 1,000 or so before the deadline. And the vast majority of them are passing. Now, here's an opportunity to ask yourselves, what do we want for our community? Do we want to be in favor of keeping our authority to regulate, public roadways, or do we want to encourage owners to vote against it? And that's a double-edged sword, and it's a philosophical question. And the answer is, I don't know. That's really up to you and your community. I'm just an advisor. I will acknowledge that regulating public street parking is expensive, it's risky, and it's just hard, right? It's just plain hard. And so if your community has determined, hey, these are pretty wide streets, we never really had a problem with first responders, being able to access a property because there's people parked on both sides, well, then maybe you just say, hey, we're going to push against keeping our authority. But however you decide, that's up to you. How do you limit your liability? Well, just have the vote. Just vote. Just call for the vote, send out the ballots. As long as you do that, you're golden. Now, if it actually passes, and a lot of them, the vast majority of them are, you should record a resolution regarding the outcome and have it recorded. We happen to have, a flat fee package where we do the opinion letter to the board. We do the notice of the meeting and the ballot for a flat $950. And we also, if it passes, we'll put together the resolution for you for an additional $250. So it's a tight economic package. So if you need help with that, let us know. I will also mention, I've had some communities in which there have been discussions, and these are communities in which they're typically gated, so this isn't going to usually apply to them because we're dealing with private streets now. But the question has been, the documents only allow parking on one side of the street, or they don't allow parking on the street at all. Can we allow it on the street? And we've got experience with that. We usually get a hold of the local fire marshal, planning and zoning. We look at the plat and we figure out, is this something that the board can do to make parking more accessible? Sometimes it requires an amendment to the CCNRs, but that's not something you really should do without talking to your legal team. And a lot of times it often requires at a minimum amending rules. Sometimes it's going to require like a CCNR amendment. So if you're a private gated community that's dealing with those types of issues, I would not anticipate any need for you to obtain this vote we talked about, but you might have some other questions as well. I'm going to go through some materials real quick and share with you. We've got our statute books that recently were updated. We're going to make those available to the management team, and if you'd like a copy of those are free. Just reach out to them. We'll make those available to you. we've got our new law guide, which summarizes all of this year's changes in the law. You know, that parking bill that I mentioned about 10 minutes ago, that was from last year's. But we've got materials on that. And of course, we also offer collection services. And so if you would like to know what's changed with regards to collections this year, what's our option, we've got some info on that as well. And if you need some assistance with condo insurance notification, we can.
Everybody